first is a case, you know, that we've stayed across here on Credlin from the outset. And I know many of you would have been disheartened with the result on Friday when the federal court found in favour of transgender woman Roxanne Tickle, who successfully sued Giggle for Girls and its owner, Sel Grover, for discrimination. This decision's likely now to have huge ramifications for how we understand sex in this country, with the judge in this case, Justice Robert Bromwich, actually saying that sex is changeable and non-binary, saying that the concept of sex has broadened over 30 years since the Sex Discrimination Act. Well, joining me for some legal common sense, legal affairs contributor at The Australian, Chris Merritt. Well, Chris, if I had expletive after expletive on Friday, what's been your reaction to the judgment?
Much the same. Forget about how we feel about this. It's starting to look as though this decision might be wrong in law. It hangs on a very modest interpretation of a crucial defence in the Sex Discrimination Act, which seems to have been read down almost to oblivion by Justice Bromwich. That's problem number one. Problem number two is this all hangs on changes to the Sex Discrimination Act that were made in 2013 by the then Labor government. And it forms a stark contrast. This case forms a stark contrast with a case very similar, which was handed down in 2011, just before these amendments were introduced. That 2011 case went exactly the opposite direction. It was about an all-female gym class that excluded legitimately a man who wanted to join it, and the federal court upheld that. Then we have 2013 amendments which introduced gender identity as a head of discrimination. Can't discriminate against people on the basis of their gender identity. And this case, the Giggle and Tickle case, is the first substantive decision we've had since that ruling in 2013. Now, it will go on appeal, either to the full federal court or the High Court, depending on whether it's a factual dispute or a dispute on the law. But it strikes me that if the law has been interpreted by Justice Bromwich in the way that it has, there's a clear case for statutory intervention. I went back and had a look at the second reading speech that
So did I, Chris.
Mr. Dreyfus introduced, and I couldn't see any reference there to an intention to treat transsexual people, men who identify as women. I would have imagined that if that was the intention of the amendments, it would have been spelled out quite clearly. And I saw no mention of it. So I'm of the opinion that this case has been applied in a way that has not been intended by Parliament. If it's not overturned on appeal, or even if it is overturned on appeal, I think there's a strong case for Parliament to go back and clarify the law so that there can't be a repeat of this.
I think you mean transgender when you said transsexual, because they're two different things. But I remember the debate very well at the time. I was working for the then opposition leader. And there was plenty of chamber speeches about, in this amendment, continuing to protect the rights of women to single-sex spaces. I couldn't find the explanatory memorandum. We know that that's also helpful in interpreting where Labor was headed with this legislation. I will look for that today or tomorrow and come back again on this program and explain that. But I'm of the mind with you, even if Sel Grover was to win on appeal, this must be something that, if elected, the coalition says it's going to amend and make it absolutely crystal clear what the rights are for women at law, women and girls, and protect our spaces and not leave it to the vagaries of cases like this and judges who obviously were asleep in a science class but can't understand XX chromosomes versus XY chromosomes. Hey, while I've got you, I want your legal brain here, because I can't fathom this decision last week in the Senate where they voted against a motion that would have applied a national rule for babies born alive after a late-term abortion. We know that in South Australia and New South Wales, those children, because they're separated from the mother in this case, that they're not in the womb anymore, have the same rights that you and I have, but not in Victoria and not in Queensland. Now, I thought once the child was no longer in the womb, they had the human rights we all have. Otherwise, it's infanticide. What am I missing? Nothing.
I agree with you entirely. The thing that strikes me is that unless there's clear legal guidelines on what to do in these horrific circumstances, it leaves medical staff, nurses and doctors in a terribly vulnerable position. They've got no guidance, no support, no framework on what they can and cannot do. So there's a potential for them, if whatever they do, to incur liability, either civil liability or criminal liability. So it's a sort of thing that Parliament should be involved in, but it's also the sort of thing that I would have imagined that the human rights commissions and human rights law centres, that we have plenty of these, should also be taking an interest in this. The fundamental right to medical treatment of these children born alive after a failed termination should be addressed.
They are human beings, Chris. The moment they're separated from the mother, there's no other way you can cut it. And I agree with you about nationally consistent laws. Thank you for your time.